So good afternoon, everyone, and welcome. Thank you for joining our webinar today that is titled Industry Legal Challenges to the SEC Private Funds Disclosure Rule and What's at Stake. So as a reminder, a recording of this event will be available on YouTube later this afternoon, of which we are happy to share the link. And then also we will have time for attendees to ask questions after our panelists have given their remarks this afternoon. So my name is Andrew Park, and I am a senior policy analyst at Americans for Financial Reform, where I cover our organization's work in both private funds and private markets. And I'm joined today by our esteemed set of panelists who will look at the assortment of legal challenges that are being brought by various industry groups. These are being brought against the Securities and Exchange Commission and a lot of its recent rulemaking. And we're also going to be talking about this broader attack on the authority of federal agencies to be able to set rules. So to start this webinar, we'll first start by looking at one of the recent rules from the SEC that is being challenged right now. And I'm referring to the SEC's Private Fund Advisors Rule that was finalized last year that sets an important standard for the $23 trillion in private funds and requiring advisors to disclose basic information around a detailed set of fees, expenses, returns, as well as disclosing any sort of special arrangements that exist to different investors, often referred to as side letters. So even though the Private Fund Advisors Rule is a simple disclosure rule, and again, it's disclosing information that the fund advisors already collect internally, this is a rule that is suddenly being challenged by a number of industry groups. The lead plaintiff in that group goes by the name of the National Association of Private Fund Managers, and was only created in April of 2022. And what's interesting about this organization is that there's absolutely no information available about who its members are or where its members are necessarily located. And yet there seems to be this tenuous claim that its suit against the Securities and Exchange Commission should be heard in the Fifth Circuit. And given the fact that it is located and registered in Fort Worth, Texas, and of course, despite the fact that the majority of the private funds industry is not based in that area. And so we'll learn more today also about an argument that we are increasingly seeing from the industry, not only just challenging the Private Fund Advisors Rule, but also questioning whether federal agencies have the ability to promulgate rules without the explicit approval of Congress, oftentimes referred to as the major questions doctrine. And finally, our webinar will delve into what exactly are the consequences if the courts overturn rules, not just such as the Private Fund Advisors Rule, but also strip the SEC's authority to make a number of rules. Because despite the industry's argument around rules being burdensome or harming capital formation, we've come to see that both businesses and financial markets have come to rely heavily on this widely accepted system of disclosures and investor protection against fraud, omissions, and other types of conflicts of interest that have really been critical to making sure that both investors feel comfortable to invest and businesses can issue in our financial markets. So first, we'll take a look at the circumstances of what it's like to invest in the $23 trillion private fund industry and what has really necessitated the SEC's recent rules through its Private Fund Advisors rule. So our first panelist today is Neil Prunier, who is a Senior Director of Industry Affairs at the Institutional Limited Partners Association, or ILPA. ILPA represents over 600 different institutional investors, many of which are our country's pension funds who invest in the private markets. And today, Neil will talk to us some more about what exactly does it entail to invest in private funds. Why is this not necessarily a transparent process? And talking to us some more about the structural imbalances that exist between private fund advisors and the investors in those same funds. So with that, I will turn it over to you, Neil.
Thanks so much, Andrew, and thanks so much for inviting me and giving me the opportunity to speak today. It's a pleasure to be here, and it's somewhat ironic that you had to specify what case and what we were talking about as it relates to the pending litigation, because there has been an influx of this, and the private fund advisors was actually the first case that ILPA submitted an amicus brief on behalf of. And I'm going to go out on a limb and say it's not going to be the last in the next several years, based off of just the velocity of court challenges that have been coming up and that we anticipate to come up as we go forward. So when we think about, though, if we take a step back, what are the problems in the industry today and where are the proposed benefits from the SEC with the private fund advisors rule? One of the things that we like to say at ILPA is private equity is good, but it could be better. And I think in some ways that parallels to the private fund advisors, the PFA rule itself. Part of it we really agreed with and thought were really good and would have significant benefits for LPs. And part of it we didn't agree with as much. But all in all, we thought it would have meaningful benefits to LPs and the private equity industry as a whole. So we wrote the amicus brief not as a point-by-point defense of the PFA, but rather to support the SEC's mission and to push hard to ensure the SEC maintained regulatory authority over private funds. We feel very strongly that the SEC plays a critical role in the industry and wanted to push hard to preserve that role. And not to step on my fellow panelists' shoes and some of the sections later on, but seeing the full extent of what the GP side pushed for in their briefs and in the litigation itself was very concerning. Because we have seen meaningful benefits for LPs since the passage of Dodd-Frank, and want to continue to see the SEC playing that meaningful role. So we did really believe that the private fund advisors rule fell fully into the SEC's three-pronged statutory mandate that includes investor protection, maintenance of fair and efficient markets, and the facilitation of capital formation. And we think that these three-pronged mandate is very much aligned with ILPA principles and our historical focus, not only on standards, but on the three key themes of alignment of interest, transparency, and governance. So what were the problems with the industry today, and why did we think the SEC needed to get involved? Well, it all starts with the negotiating process and challenges LPs face. Even the biggest, most sophisticated investors really have difficulties with moving fund terms during negotiations in a meaningful way. We've surveyed our members over the last several years, and what we've found is that 97% of our members have reported that the starting point of the LPA negotiation has shifted in favor of GPs, and 87% have identified that the ending point of negotiations have shifted towards the GP's favor. Part of this is due to the structural challenges in the industry related to the bargaining problem. So we could have a real fun conversation about the principal agent equation and game theory. We can also talk about the high switching costs for LPs and how it's difficult to walk away despite not always being thrilled with the negotiated outcomes. We can also talk about some basic things like the significant consolidation in the GP external counsel market and the significant pushback said external counsel makes in any changes to the LPA and pushes everything to the side letter itself, to the point where the LPA has become, in essence, a marketing tool for many of these GP external counsel. So when we think about the benefits, this goes back to the negotiation process and the idea that as an LP, you can only focus on a few what we call must-haves during negotiations. And the benefits in many aspects were to raise the minimum standard to create a better, more transparent and aligned starting point by taking some of the core elements of negotiations off the table. So for example, taking the really critical piece of fee and expense transparency off the negotiation table and making it more table stakes. When we've surveyed our members, we've found that fee and expense transparency is the #1 must-have for LPs in negotiations. However, only 8% of LPs have observed GPs being willing to commit to providing the ILPA reporting template in LPAs, meaning each LP then needs to spend time negotiating for this transparency within their side letter, which is a very inefficient practice, which is a very costly practice, and which might mean that certain LPs aren't able to negotiate for it if they're not able to prioritize it, or aren't able to receive it if they're not able to prioritize it during side letters, or excuse me, during negotiations. And sometimes side letters can get a bad rap, but at times it's the only way to make progress in negotiations due to what we've seen in the GP external counsel market and how important that LPA is from a marketing standpoint. Next up was fiduciary duty. And this actually didn't end up fully in the final rule, but this had been something that ILPA was a big supporter of with tweaks to the negligence levels. But this is typically the #2 must-have for LPs in negotiations. And it's also the #1 term that has shifted most in favor of the GP, given how much fiduciary duty is frequently weakened from hedge clauses and other carve-outs. So ultimately, we see benefits in being able to raise the minimum standard due to some of the defined structural issues that LPs face in the industry, despite being very sophisticated, very capable investors.
That, Neil, and certainly some stunning figures you certainly share with us there, especially around the 97% and 8% that you have just mentioned. So we will then again, as a reminder to everyone, if you have any questions for the panelists, to please use the Q&A function or also the chat function as well. We'll next turn it over to our next panelist, Thomas Burns, who is a founding shareholder of Burns PA. And so by way of background, Thomas is a graduate of Duke Law School and a former clerk on the 11th Circuit, and also an escapee from the appellate departments of some of the biggest law firms in Washington, D.C. And so he is now a board certified appellate lawyer in Tampa, Florida, and has, as a lead counsel, litigated across 25 or 250 state and federal appeals, and has presented in front with dozens of oral arguments. And so in the finance space, he has helped a number of public interest groups, both in supporting or defending against industry challenges to the SEC actions or the scope of securities laws in different appellate matters across the Supreme Court, the DC Circuit, as well as the Second and Fifth Circuits. And so Thomas worked with Americans for Financial Reform to submit an amicus brief in the Fifth Circuit, and will explain to us why the SEC has authority under the Investment Advisors Act to implement the private fund advisors rule, the limitations of the petitioner's challenges, which we'll note is only to a few pieces of the rule, and also offer us some more context behind other cases that have come in front of the Fifth Circuit and how that's relevant to both the private fund advisors rule and also many other rules as well. And so with that, I will turn it over to Thomas.
Yeah, thank you, Andrew, for the lovely introduction and for inviting me here to speak today. It's actually great to hear from Neil, because it was like his amicus brief came to life with some of the very useful figures about what's actually happening in the trenches in this market. And ILPA submitted this amicus brief also, and I thought it added tremendous value to our side of the issue. So when we're talking about appeals and a legal issue, you got to kind of consider two things. One is the judicial audience, and then the other is like what the actual issue is, or the message that both sides are trying to convey about the issue. So let me start with a couple comments about the Fifth Circuit, and then we can talk a little bit about how the briefing and the oral argument played out, and I can give you kind of my prediction of what I think is possible outcomes of the case might be. And then, the other panelists can talk about what are the consequences of those possible outcomes. So the Fifth Circuit's one of the regional appellate courts in the United States. It's got 17 active judges. It tends to lean more conservative than some of the other circuits. And, it's based in New Orleans, hears appeals from Texas, Mississippi, Louisiana. And it's in kind of recent years gotten a reputation for being very receptive to challenges of agency action. And just to name a couple of the cases that have come up kind of recently, there's the SEC against Charkisi matter, which is now in the Supreme Court. The issue there is whether SEC enforcement proceedings are unconstitutionally violate the Seventh Amendment. That's reviewing a 2022 decision of the Fifth Circuit. Most people think that the Supreme Court's likely to affirm the Fifth Circuit's ruling that it is unconstitutional, but we're still awaiting the opinion because that case was argued late last year, November 29. There's another case pending in the Supreme Court called CFPB against Community Financial Services Association of America. There, the issue has to do with how the CFPBs gets its appropriations from Congress and whether that's unconstitutionally violates the appropriations clause. Most of the people who follow the briefing and the oral argument tend to think that the Supreme Court's likely to reverse the Fifth Circuit's decision, holding that it was unconstitutional. And then there's a lot of other cases that maybe don't get the same kind of press for people, especially in the financial sphere, having to do with civil rights and other government actions, where the tendency of the Fifth Circuit is to arrive at results that probably other circuits would be unlikely to reach. Some of those cases are now in the Supreme Court. Maybe most notably is the United States against Rahimi case, which is a Second Amendment case having to do with domestic violence restraining orders, or as I like to think of it, the issue is if Yosemite Sam had a domestic violence restraining order against him, could Congress disarm him? And most people who are watching that case tend to think that the Supreme Court is likely to reverse the Fifth Circuit's ruling in that case and hold that Congress does have that authority. And if you want like a broader view of maybe how, or from a very particular viewpoint of recent Fifth Circuit rulings, there's an article written by Professor Stephen Vladeck, formerly of the University of Texas Law School, but he's recently just accepted a position at Georgetown Law School that was published late last year in the Atlantic, and it's kind of a recent historical summary of some Fifth Circuit decisions that have attracted the eyes of lots of people. One of the things that Fifth Circuit has been a little bit unusual is, I would say, kind of from 2000 to 2015, or even as late as 2018, Fifth Circuit really wasn't that much different, I think, from many other circuits in terms of its viewpoint and a lot of the results it was reaching. But there's something different happening in the Fifth Circuit since about 2019. And so if you just collect the statistics of reversal rates in Supreme Court decisions, the Fifth Circuit's had a lot of reversals in the Supreme Court. So in 2019, the Fifth Circuit was reversed 6 out of 7 times. 2020, Fifth Circuit was reversed 5 out of 7 times. 2021, Fifth Circuit's reversed 7 out of 8 times, and then the same number in 2022 is reversed 7 out of 8 times, for a total in the last 4 terms of 25 out of 30 reversals. Now, you might think that's an extremely high number. It's not maybe as high as you think, because overall, the average, when the Supreme Court takes a case from a United States Court of Appeals, it tends to reverse in about 2/3, sometimes 3/4 of the cases. So that the number of reversals in the Fifth Circuit is above the average, but it's also not the highest in the number of reversals. The court that gets reversed the most in the Supreme Court seems to have always been the Ninth Circuit, which over the last 4 years has been reversed 47 out of 52 times, for a reversal rate of over 90%. That's an unusual figure, because the Fifth Circuit and the Ninth Circuit don't really have caseloads that are that much different. Fifth Circuit has about 4,800 cases per year, whereas the Ninth Circuit has 5,200 cases per year. But anyways, there seems to be something a little bit different happening in the Fifth Circuit over the last 4 or 5 years. And so it's a different type of judicial audience than you might have otherwise in other appellate courts. The panel here in this particular litigation consists of judges Southwick, who is appointed by George W. Bush. He sits in Jackson, Mississippi. Judge Engelhardt, who is appointed by President Trump. He sits in New Orleans. And Judge Wilson, who is also appointed by President Trump and sits in Mississippi. And he also happens to be the judge who authored the decision in Rahimi. Now, none of these judges, I think most people would characterize as firebrand judges or anything out of the ordinary in the Fifth Circuit, but they're not the kinds of judges who would come in with a healthy amount of skepticism when the government says that it can regulate something, anything. So it's a tall order in this case, just given the audience that the SEC has and that the amici that are supporting the SEC have. And I think the briefing almost could not have gone better for the SEC side and the amici. Like I think we really did on our side present our case very well, as did the petitioners. They're represented by one of the best law firms in the country with some really talented lawyers. So it's very keen. They put a very fine point on not just what's at stake here, but what the legal issue is. And one of the things that Andrew mentioned a couple of minutes ago is the SEC actually adopted 5 different rules here, plus some amendments. So those rules are the quarterly statement, preferential treatment, restricted activities, audit, and advisor-led secondaries rule. And then there are some amendments having to do with annual compliance, of documentation, and the retention of books and records. But the petitioners here made it kind of an intriguing litigation choice, which is that they're not challenging everything. And instead, they decided to pick off a couple of the things that they thought were most open to attack. And in their view, their best place to attack were the quarterly statement, preferential treatment, and restricted activities rule. So one of the core themes that kind of emerged at both through the briefing and at oral argument is like, well, what is the Fifth Circuit as a court supposed to do when only 3 of the rules have been challenged? Does the baby go out with the bathwater and we throw out these other rules that were not challenged as well? Or do we look at each thing individually and it stands or falls on its own merits? Now, obviously, the SEC took the position like, well, you have to look at everything individually, and this is a piecemeal kind of analysis. But the petitioner's view was like, no, this thing is flawed from root to branch. That's what they said in their brief. And then they had, I thought, some clever turns of phrase, not just in their brief, but also at oral argument about why the court could throw out the whole thing as opposed to just the individual rules. We'll see. I kind of felt from listening to oral argument that the judges were skeptical that they had that much authority. And I think they're going to look pretty closely at that issue before doing anything. On the other hand, as to kind of the core legal issue, this is a textual interpretation issue about the various provisions that are governing securities. And one of the petitioner's points was like, well, they're sort of picking it there. The SEC is kind of picking and choosing between provisions that appear in totally different parts of the act. And on the one hand, the SEC's got kind of a good textual argument, which is like, well, one of those things says more or less retail investors, and then the other thing just says investors, and so therefore Congress meant something different in those 2 places, and we do have the authority to regulate this these private fund advisors. And the petitioner's argument is more of like a contextual one. It's like, well, no, you got to kind of understand the background of this market. And, when you're talking about private funds, and this is like a core premise of their argument. It's like, well, when you're talking about private funds, you're only talking about the big boys who can fend for themselves. You're talking about the, sovereign wealth funds or university endowments that are enormous. And that's actually one of the things that not just the SEC, but the amici supporting the SEC were harping on in the briefing. And I thought, for example, ILPA's brief did a really wonderful job of this, saying, well, it's not just the biggest, most sophisticated investors that are involved in these private funds. You also have much smaller entities that face consequences from how these things play out. But also you have these like enormous pension funds that still can't get the information that they want, and there's all sorts of inefficiencies, as you heard from Neil, and if you read their brief, you'd see as well that the market isn't functioning the way it ought to. So our argument for Americans for Financial Reform, we supported the SEC saying that the Investment Advisors Act of 1940 gave the Commission its a broad anti-fraud statutory authority, and that allows it to adopt prophylactic measures to prevent the fraud from occurring in the first place. We also pointed to the Dodd-Frank Act. And we mentioned some other things that historically that nobody's questioned the SEC's ability to do. So, for example, there's a thing called Form ADV, and that asks certain questions that there's no statutory basis for the SEC to ask. But nobody's questioned in decades that the SEC actually can do that pursuant to its anti-fraud powers, like statutory anti-fraud powers. We also supported the SEC in terms of why this was, a good policy in how the SEC had done its homework, because it promotes transparency, reduces conflicts of interest, and it protects investors. And then we also took a little time walking through a little bit of the administrative record, where we're explaining, some of the comment letters that had been submitted as part of the rulemaking process. And then the majority commissioner's actual statement saying, like, this is why we want you, why we're agreeing with and adopting this rule. The one final thing that, Andrew at the top of the hour mentioned, we asked the court, we invited the court to ask some hard questions about the standing of the National Association of Private Fund Managers. That it's an unusual entity in that we don't know a whole, like, publicly there's just not very much known about it. And we said, take a close look at this Fifth Circuit, because this could be a way that they're trying to engage in forum selection, which generally is frowned upon in litigation. At oral argument, we even proposed some questions that they might ask at oral argument. Fifth Circuit didn't ask any of those questions. So it looked to me as an appellate lawyer that they were focused on the merits of the issue, not the procedural rigmarole about getting there. And they're going to write some kind of opinion that addresses those issues. Now, it's always difficult to read the tea leaves from the briefing, the oral argument, and predict a result. But if you held a gun to my head and said, Thomas, you must predict what's likely to happen here, I think there's a substantial possibility that one or more, the Fifth Circuit might reject one or more of these rules. I would be surprised if the Fifth Circuit threw the baby out with the bathwater and said, well, not only do these three rules fall, but the whole scheme of regulating the private fund advisors falls as well. But I wouldn't be that surprised, because the Fifth Circuit has written these expansive opinions in the agency litigation space before, and even on other issues, like I said, about civil rights and government, the scope of government powers. And I don't think the Fifth Circuit's going to dig into the standing issue. So I think this is going to be a merits decision. It's going to be based on the panel's interpretation of the statute, and there could be substantial consequences for that ruling. So I think that's where I hand it off to the other panelists who can explain what some of those consequences might be if it comes to pass that the Fifth Circuit rules in favor of the petitioners.
Thank you for that, Thomas. And so we just heard from both Neil and Thomas about the issues and the issues that are at play in the private funds industry. We'll now expand a little further now and look at similar issues that we see on the private market side of things. And so we'll be hearing from Professor Anat Alan-Beck, who will be talking to us about what those issues are, and the fact that you have this inherent lack of transparency and investor protection in the private markets, and talking about why have these markets grown so largely in the past decade, and really just how the regulation has not kept up with that type of growth, and and why the SEC's oversight over these markets are particularly important. And so by way of background, Professor Alan-Beck is an associate professor at Case Western University School of Law, and her research focuses on both corporate law and governance, and examining how legal and regulatory structures influence the shift in investment from the public markets to the private markets, and especially the rise in the number of firms that label themselves as unicorns. And so a significant amount of her research has been cited in the US Congress, the SEC, and also in the Fifth and Ninth Circuits. And Professor Alan-Beck also has a column on Forbes for those who are also interested in some of her recent publications. And currently she sits on the Association of American Law Schools, the section on transactional law and skills executive committee, and also chairs the academic subcommittee of the ABA's Private Equity and Venture Capital Committee in the business law section. So I'll turn it over now to Professor Alan-Beck.
Thank you so much for having me today, Andrew. It's really an honor. And what I'll do is I'll discuss a little bit on the macro level what's influencing this in terms of the inherent lack of transparency and investor protection in the private markets. And then I'll also describe what's going on in our equities markets generally, and that is a rise in private markets versus public markets, and conclude with how does all this affect what's going to happen if the court actually trims the SEC's authority in the future. How is that going to affect our private markets? And so first, I want to start with the inherent lack of transparency and investor protection in our private markets broadly. As you know, some of the previous speakers, Tom and Neil, mentioned that private markets are plagued with what we call asymmetric information, illiquidity, and today also long holding periods, and I'm going to explain. As a result of that, we need to take these factors into account before we talk about any type of serious policy response to these changes, or how, of course, decisions as a result are going to affect these markets. And transparency that is traditionally associated with public markets, unfortunately, is not available in the private sphere. In fact, what we can see is we have this change in our equities markets. I started looking at this during my doctorate, actually. I saw this decline in a number of public firms, and I saw this rise in the number of private firms, and that's why I chose to focus on unicorn firms. Those are private firms that are worth over $1 billion. And I would also say that if public firms were a species, I would say that we could possibly call it extinct, because we're seeing less and less of them, and they're also listed for less time than in the past. Okay, so their numbers fall, and as a result, we don't have the efficiencies that are associated with the transparency of public markets. Those are diminishing overall. And so if we take a look at the private equity markets, they are associated with opacity. They're dark. That's why we call it going dark. When you go private, you go dark. And what's happening, and it's also causing, I think, overall among the general public, it causes a diminishment of support for overall the corporate sector in the long term in these private markets. And it's unfortunate. And so what's happening also is that on the one hand, we have regulators and the market itself that's pushing for more public market-like disclosures. And we're seeing that as more and more public capital is actually flowing into the private markets. And you mentioned the fact that we don't have enough disclosure. Even those large big boys with all this power don't even have all the information that they need in front of them. And on the other hand, we also need to take a look at the private markets, and they're important. We should mention the fact that they're important. Financing of private markets is also very important. Why? Because in the private markets is where you're financing a lot of the technology, innovation, especially companies that are associated with intangible assets. Private markets are better sourced, honestly, to alleviate this lack of disclosure of information, this asymmetry of information. And what they are supposed to do is they need to ensure that investors of all sophistication can make informed decisions. And as a result, we need to have more protection implemented in order to maintain the support of our corporate sector. And that's my opinion. I think we need more transparency, and transparency in our private markets is going to also increase our society's access to these private markets. And let's just quickly talk about our securities laws. And remember one thing, our securities laws were designed to protect all investors, okay? Not just the big players or small players. We really need to take this into account. They were supposed to and designed to protect all investors. And what it means that all companies in the United States were required to disclose financial and other types of information about the offering firm, for example, before offering any securities to the public. But unfortunately, things changed. And what happened as a result of lobbying and deregulation that happened, by the way, throughout the years with the different administrations. And that is that a lot of private companies today enjoy exemptions from registration. And that happened thanks to a series of reforms to our federal securities laws. And by the way, that type of reform started in 1988. Okay, so there's nothing new there. And these changes dramatically reduce the ability of different type of groups to be pressured to do an IPO. Why would they do an IPO today? Why would they go public? And I'm telling you, the number of public firms is diminishing. When you go public, you have to disclose information. So why would they do that? They have no incentive of doing that when they can raise so much capital in the private markets without having to disclose information, and they enjoy this opacities. And there is this type of this consensus, I want to say, among a lot of scholars that we need more disclosure. Now, with that consensus, there's also debate. And the debate is on what type of information do we want these private players, these private companies to disclose to alleviate the problem, okay? And there's different types of approaches to disclosure. But what we really need to think about is, do we want to have the more maximum way of disclosure or the more minimum? And what's happening is that at the same time we have this creation of secondary markets and increasing sophisticated exit mechanisms that are negotiated by large institutional investors. And as a result of those changes as well, they've decreased the attraction of the liquidity mechanisms that are associated with our public markets that are offered for so many and with a really broad shareholder base. And so what we're seeing is this consolidation of ownership of equity in the United States into large institutional holders. And we're also seeing a diminishing prestige that's associated with going public. And now, how does these changes affect what we're seeing in the market? We're seeing an explosive growth of private markets. And I think this is honestly one of the most important developments in our securities market in this new millennium. And like I said, we have this shift from public markets to private markets. So we need to take these implications of these changes very seriously for all types of investors, including retail investors. How is that going to affect retail investors in the future? And think about the following. As companies continue to stay private longer, as they continue to raise more capital in private markets, our regulators are also pressured into changing this current trend. So what do we want them to do? What are the tools that we're giving them to cope with these changes? And I've heard different approaches. By the way, I've heard an approach that says we need to democratize access of retail investors into private markets. Or I've also heard another approach, and that is we need to force more private companies basically to go public so we can maintain this efficiency and disclosure of information. Now, let me also touch just briefly on what's going on with the SEC and what's going to happen if the SEC will lose its authority and power to affect these markets. And as you know, there's been a lot of drama about the private funds reform overall. And let's quickly just touch on, I think, 3 major areas that should be discussed. And that is, 1, the reform is geared towards more transparency of actions in corporate governance. 2, some of these rules are intended to ensure fairness between the different types of investors. And 3 is the need for greater accountability and auditing requirements. And most of these prohibitions are related to really not allowing funds to, for example, charge investors with fees for various matters, for how they recoup, expenses that are related to regulatory investigations or compliance charges. How are they allocating fees? We want more disclosure on the non-pro rata basis, and things that have to do with borrowing money from other funds without investor consent. And just 2 more things, and that is, 1, let's remember this is over a $14 trillion industry that they're trying to regulate. And we do also need to take into account that fund managers might take a hit themselves as a result of this greater transparency. But on the other hand, I don't know if we have any lawyers or auditors or other financial advisors here in the room. I can see that they might even benefit from this. They'll need them more. They have more things that they're going to have to take into account and be consulted with. But think about the following. I think that the real question is here, how is this going to affect the bottom line, the clients? Okay? How is it that it's going to affect the investors? Even retail investors in the future. And that's where I think we should focus our discussion on. Thank you.
Thank you, Anat. And so, we've heard about from the panelists the issues that we see in both the private funds and the private markets with the lack of transparency. And again, why, Anat, I liked how you talked about the need to protect all investors. And so, for our next panelists, we will then start looking at the issues of what happens if we start to see, in addition to some of these rules being challenged and potentially overturned, what are the consequences if the authority of the agencies themselves start to really come into question? And that's where I'll be turning it over to our next panelist Brienne Gorad, who is the chief counsel at the Constitutional Accountability Center, who has also filed an amicus brief in the private fund advisors case. And so by way of background, Brienne's academic writings have appeared in a number of law journals, including the Yale Law Journal, the Duke Law Journal, and also the Northwestern University Law Review, as well as the law reviews of both WashU and NYU as well, in addition to many publications and popular law blogs. And so she will talk to us a little bit more about what exactly are the consequences if courts start to become sympathetic to the issues being raised by the major question doctrine of, can agencies promulgate rules without the consistent, explicit authority or approval of Congress? And so I will turn it now over to Brienne to talk us through that some more.
Great. Well, thank you so much, Andrew, and thank you to AFR for organizing this webinar and inviting me to join you. As Andrew said, I want to zoom out a bit from the particular rule at issue here and talk about the legal doctrine that's being used to challenge it, what's called the major questions doctrine, and the broader implications of that doctrine. This is incredibly important for anyone who cares about SEC authority or, frankly, regulatory authority more broadly, because the major questions doctrine is now being used to challenge countless regulations issued by different agencies on a whole range of different topics. So I'll start with a little background on the doctrine and then talk about why the doctrine is actually much more narrow and applies much more rarely than opponents of regulatory authority claim. So what is the major questions doctrine? Well, this doctrine was first articulated as such in a case the Supreme Court decided a couple of years ago called West Virginia v. EPA. This case was about whether a regulation issued by the EPA to reduce greenhouse gas emissions from power plants was authorized by the Clean Air Act. Those challenging the rule argued that it wasn't. According to them, laws passed by Congress had to speak with unmissable clarity, that's their language, before authorizing an agency to address matters of major political or economic significance. The court ultimately agreed with the rule's challengers, at least to the extent that there is a major questions doctrine that applied in that particular case. So you fast forward to 2024, and the major questions doctrine is being invoked in litigation all the time, being used to challenge regulatory action basically any time an agency attempts any remotely significant actions in pursuit of its mission. That's the bad news. The good news, such as it is that the doctrine should not be interpreted that broadly. Instead, it should apply only rarely in extraordinary circumstances, which notably is exactly what the Supreme Court said in West Virginia. Multiple times in its opinion, the Supreme Court majority used the term extraordinary to describe the context in which the major questions doctrine applies. So we filed an amicus brief in this case, making exactly that point, that the Supreme Court's own precedent requires applying this doctrine rarely, only rarely, when agencies advance startling new claims of breathtaking, staggering, or extraordinary regulatory power, and when numerous factors indicate that the agency is attempting to exercise authority that Congress never meant to grant it. Expanding the major questions doctrine beyond that limited sphere, we argued in our brief, would not only defy Supreme Court precedent, but would also be at odds with textualism, the original understanding of the Constitution, and the separation of powers. We began our brief with the court's own precedent. As we explained in recent years, the court concluded in several prominent cases that agencies were claiming enormous new regulatory power, despite indications that Congress did not intend to grant them that authority. And so what West Virginia v. EPA did was take stock of that case law, expressly recognize the major questions doctrine, and explain that precedent teaches there are extraordinary cases that call for a different approach from routine statutory interpretation. In those extraordinary cases, courts take an extraordinary approach. Rather than doing what courts normally do when they're interpreting a statute, simply trying to determine the original public meaning of the statute's plain text, courts instead weigh various factors outside of the text to help decide whether a major question is implicated. Because this approach is so different from what courts normally do, the way they normally interpret statutes, the Supreme Court has tightly limited the application of the doctrine, confining it to truly extraordinary claims of authority that amount to a fundamental revision of the statute, changing it from one sort of scheme of regulation into an entirely different kind. In other words, the major questions doctrine has two separate and highly demanding requirements. First, an agency must be claiming breathtaking new powers with staggering economic and political significance. And second, The agency's claim has to represent a transformative expansion in its regulatory authority that stretches beyond what Congress could reasonably be understood to have granted. It is not enough, as opponents of regulatory action would have it, that an agency action has broad economic and political significance, nor is it enough that the agency action goes further than what the agency has done in the past. Major questions doctrine should only apply if there is evidence that the newly claimed power is inconsistent with the authority that Congress meant to confer. And notably, this interpretation of the doctrine is consistent not only with the court's decision in West Virginia VPA, but also with the court's more recent decision in the case challenging the Biden administration's student debt relief plan. We also explained in our brief why extending the major questions doctrine beyond such truly extraordinary cases would conflict not only with the court's own precedent, but also with principles of textualism. Unlike the ordinary tools of statutory interpretation, the major questions doctrine emphasizes factors outside of a statute's text and its structure, including the subjective expectations of the legislators who passed it and developments that arose after it was enacted. Some of these factors require judges to venture beyond their judicial expertise by assessing the economic ramifications of an agency action or assessing the intensity of a political controversy. And many of these factors have simply no bearing on a statute's original public meaning because they're focused on events that occurred after it was enacted. The major questions doctrine thus risks subordinating a statute's best reading to these non-textual considerations. And this is something that justices across the ideological spectrum have recognized. The major questions doctrine should also be applied sparingly because it's in tension with the original understanding of the Constitution. The doctrine presumes that Congress intends to make major policy decisions itself, not leave those decisions to agencies. But Congress has tasked the executive branch with resolving major policy decisions since the nation's founding, when it routinely granted the executive vast discretion over some of the most pressing economic and political challenges facing the nation. Nothing in the Constitution forecloses that choice, and history doesn't suggest that Congress has to speak in any particularly clear manner to exercise it. Finally, a too permissive use of the major questions doctrine would erode critical limits on the role of the judiciary, threatening the separation of powers. The doctrine aims to promote separation of powers principles by preventing agencies from exceeding Congress's intent, but in the process, this judicially fashioned doctrine also constrains Congress itself. It blocks Congress from authorizing agency action whenever the courts decide that a major question is implicated, unless Congress uses language that the courts deem sufficiently clear. The doctrine thus tells Congress how it must draft certain types of law, demanding heightened clarity based on new concepts devised by the one branch of government not directly accountable to the people. So there are numerous reasons why courts should be very hesitant to apply the major questions doctrine, and that is a good thing. Overly aggressive application of the major questions doctrine could undermine all sorts of regulatory action, not only ones that benefit investors and consumers and workers, but also potentially ones that provide guidance to businesses and help set the rules of the road for marketplaces. So I'll leave it at that, but I'm of course happy to answer any questions during the Q&A. Thank you.
Thank you, Brianne. And it's certainly, good to hear that, the major questions doctrine, as you say, should not be interpreted that broadly and truly should be reserved for, as you say, truly extraordinary expansions of the agency power. But we'll turn now to Professor Patrick Corrigan, who will then help us think through just what are the consequences if a court would be sympathetic to some of these challenges being made more broadly to agency authority, just in the course of how would that affect both our financial markets and also the system of disclosures and reporting that many businesses are subject to that are critical to our financial marketplace operating smoothly. And so I will turn it over to Professor Corrigan, who is a law professor at Notre Dame Law School and has published some forthcoming work in the NYU Law Review, also the WashU Law Review, Yale Journal on Regulation, and Journal of Empirical Legal Studies, among many others. And so Professor Corrigan's research has been cited by the SEC in various administrative materials, including most recently the final rulemaking related to special purpose acquisition corporations, or SPACs. So Professor Corrigan, I will turn it over to you.
Thank you, Andrew, and thank you, AFR, for having me here. I'm delighted to be on this panel with such great colleagues. I'm going to zoom back on the final rule, some of the statutory and interpretive issues, and speak about some of the downstream consequences of what's at stake. I'll try to be brief. I'll make 4 points. First, the securities laws perform an important function, and they work, at least we can say this with some confidence, for public markets. Start with the example of SPACs. I've argued that SPACs are best understood as a case study of how going public transactions would work if the securities laws were optional. The pivotal difference between SPACs and IPOs, both going public transactions, is that most of the direct and indirect protections that ordinarily apply in the IPO context are relaxed in the SPAC context. In SPAC combinations compared to IPOs, issuers and their selling teams engage in more aggressive offering and selling efforts, face lower risk of liability on the back end, and utilize intermediaries that face relatively weaker reputational constraints, among other regulatory differences. What was the result of this SPAC market experiment? SPAC investors systematically received a bad bargain, and too much money went to companies now facing distress or even bankruptcy. Similarly situated IPO investors who had the protections of the public offering rules fared well at the same time. What do public capital markets look like without the mandatory protections of the securities laws? They look like SPACs. And we can point to other real-world examples: initial coin offerings and vaporware and crypto asset markets, rug pulls, and farther back, the roaring 20s. Regulation of our capital markets can and should do better. Point 2, there's now less confidence that private markets are immune from the types of problems that plague unrelated public markets. Professor Alon Beck spoke a little bit about this, so I'll be brief. But the one point I want to add is that we've seen the public equity markets go dark, and we're now seeing the debt markets go dark. Some of my colleagues have some really interesting work forthcoming. Keep an eye out for that. But one of the points I want to make is that the CDOs and the asset-backed commercial paper conduits that blew up and contributed to the Great Recession were a species of private credit funds. And today, the industry of private debt, another type of shadow bank, is again on the march. CLOs, credit funds, BDCs, REITs, all without regulation under the Investment Company Act. We have other instances of scandals in private markets. We now have some reports from the SEC and FINRA showing deficiencies of conflicts of interest in communications and deal markets and private markets. Okay, point 3, the catch-all anti-evasion authorities that are necessary for effective regulation of financial markets and smooth functioning of businesses are at stake. When interpreting Section 206 of the Investment Advisors Act in the seminal case, Capital Gains Research, the Supreme Court declared that Congress intended the Investment Advisors Act of 1940 to be construed not technically and restrictively, but flexibly to effectuate its remedial purposes. It said what is required is a picture not simply of the shop window, but of the entire store. Not simply truth in the statements volunteered, but disclosure. At stake in this litigation is the risk that courts will interpret Section 206 narrowly, limiting the ability of the SEC to prescribe prophylactic rules into police investment advisor misconduct. And this isn't the only risk. We've talked about Sharkeyzy. We haven't talked about the risk of overruling Chevron. We've talked about the major questions doctrine. This is potentially a lot of change to a nearly century-old regulatory regime in a short period. Point 4, last point. Disrupting stare decisis with a narrow and technical view of the SEC's authority will put us in a brave new world with disruptive and potentially unpredictable results for investment markets. A narrow reading of the anti-fraud rules would have downstream consequences for the entire regulatory scheme. In dynamic markets where clever transactional planners can dance around the lines of rules, Section 206 and 10B, which track language largely but not entirely, these anti-fraud authorities essentially say, thou shalt not commit any other fraud or deception. They provide a crucial catch-all and anti-evasion function. A lot of our doctrine and settled precedents rely on some of these equitable affirmative duties created under Section 10B, insider trading, fraud on the market doctrine, background interpretations, the tracing limitation in Section 11, the interpretation of prospectus and Gustafson. And it's not just, 10B isn't just used, the anti-fraud provisions aren't just used to compel disclosure, they're used prophylactically to restrict contracts and conduct. The SEC's Regulation M is based on its Section 10B anti-fraud authority, which restricts the conduct and contracts of distribution participants in public offerings. So wrapping up here, the stakes are high in the current moment. There are risks that the courts will narrow or overturn precedent. This will have downstream consequences, creating uncertainty for market participants, not just in private markets, but in public markets, while increasing the risk of fraud in allocation efficiency in investment markets. Stay tuned.
Thank you, Patrick. And that's certainly, you know, a concerning set of consequences if we start to see, you know, a lot of this critical rulemaking being challenged and questioned. And so I realize that we are over the time of our webinar. And so to the extent that folks can still stay on, we are going to turn it over now to the question and answer part of this webinar. And so I see that we have a question that is in the chat now related to the major questions doctrine. And so the question is, how are the arguments playing out in the lower courts so far? If the major questions doctrine is actually limited in scope, as asserted, what are the thoughts on the alternative non-delegation arguments being made elsewhere? And so we'll start over, since Brianne talked about that, we'll turn it over to Brianne, and if anyone else wants to jump in.
Sure. So, you know, in the lower courts, in terms of major questions doctrine and how they're applying it, you know, we're still fairly early. What we're seeing is this argument being raised in lots of cases and being considered. And we don't yet have that many opinions in which courts have authoritatively answered questions about its scope and its application. That's why I think it is really important that the courts that are considering these questions, you know, have full briefing of the issue and fully understand what the Supreme Court has previously said about the doctrine in its cases. So I think it's, you know, still very early. And, you know, we're going to continue to see lots of evolution in the doctrine in the months and probably years to come. You know, in terms of non-delegation, that is also an argument that we have seen litigants making in challenge to regulatory action. That was, of course, an argument that was made in West Virginia v. EPA itself. You know, we have not, I think, yet seen much of an appetite from the Supreme Court itself, or at least a majority of the Supreme Court's justices, to bite on a reinvigorated non-delegation doctrine. But I'm sure we'll continue to see that argument made in the lower courts. And in fact, there's a cert petition pending before the court now that asks the court to take the question, and we'll know soon whether the court, you know, is open to considering it.
I also see that a question for Thomas. Thomas, you mentioned a number of the cases that have been previously brought before the Fifth and Ninth Circuit that has been overturned in the past. I mean, is there any reason based on the current composition of the courts that lead you to believe that, you know, we would see anything similar or different to what we've seen in the past in terms of overturning previous precedent?
So the speculation, I think, is that the Ninth Circuit has always tried to push precedent in a certain direction, and the Supreme Court's always been reining them back in. And it's more recently that the Fifth Circuit is trying to do that also, but from a different judicial perspective. And the Supreme Court has also been reining them back in. I don't see either of those, given the current compositions of the Ninth and Fifth Circuits. I don't see either of those trends ending. I think they both, you know, the judges on those courts have their viewpoints and will want to push precedent in a certain direction. Now, of course, because they're both subordinate courts to the Supreme Court, that doesn't mean they just don't have the power to overrule Supreme Court precedent, but they also have the power to interpret Supreme Court precedent creatively and try and you know, get around that. And then sometimes that is successful and sometimes not. So like the recent examples would be the two that I kind of started off with, which is Jarkizi and the CFPB case. So in Jarkizi, I don't think it was really questioned for a long time that it was okay for the SEC to have these administrative enforcement proceedings without like an Article 3 judge present. But then the Fifth Circuit said that that's not okay. And it looks like the Supreme Court is going to say, like, yeah, we agree with the Fifth Circuit. On the other hand, on the CFPB case, the Fifth Circuit said, no, you know, this is a violation of the appropriations clause. And at the oral argument, the Supreme Court seemed pretty skeptical about that, in part because of the really tremendous representation that the Solicitor General provided, trying to place the appropriations for the CFPB within a very well-established historical tradition for other agencies and government expenditures. So I think this is just going to play out continually over the next 5-10 years until court compositions change, either at the Supreme Court level or at the circuit level. I hope that answers the question, but questioner, please tell me if your question was a little different.
Thank you for that, Thomas. This is a last call. If anyone else has any questions for our panelists, feel free to use either the Q&A function or the chat function. Okay, well, hearing none, we will leave it there, but I want everyone to join me in thanking our panelists, Neil, Thomas, Anat, Brianne, and Patrick for their very insightful comments today. As this is an issue that will continue to be heavily discussed, both in terms of what are the implications for these legal challenges to the SEC, and also this bigger, broader challenge to agency rulemaking authority. And so, again, for those who would like to watch, who haven't been able to get a chance, this recording will be available on YouTube later this afternoon. And otherwise, we thank you all for joining today.